Okay, so we can start in 10 seconds. It's going live.
Right.
Okay, so it's live now. We can start.
Okay. A very good evening to one and all present here. I, Ishita Keria, take this privilege to warmly welcome our esteemed guests, faculty members, and fellow students to this inaugural lecture of the two-day online workshop on mediation being organized by Uslls under the guidance of our Dean, Professor Dr. A.P. Singh Sir, and the faculty coordinators, Dr. Vanna Singh Ma'am and Dr. Zubair Ahmed Sir. Before formally commencing the event, I request all the attendees to kindly switch off their videos and mute themselves in order to avoid any unwanted disruptions. USLS has always been part of scheme for pedagogy and research in area for holistic education and academic growth. In order to bridge the gap between academia and industry and to enlighten the students about the latest developments in the field of ADR, the cell has organized this online workshop in the endeavor to instill some various practical skills amongst our students. We have with us Dr. Aman Hingorani to speak on the practical skills required on mediation, online mediation, and skills required for ease of doing business. Now, I would like to invite our revered Dean, Professor Dr. A.P. Singh Sir, the man behind the success of this endeavor of ours, for his welcome address. Over to you, sir.
Thank you, Ishita. Thank you so much. Respected Dr. Aman Hingorani, sir, my learned faculty colleagues, and I see a lot of learned lawyer friends also attending. Wonderful. And my student friends. It's a very special privilege for me to welcome Dr. Aman Hingorani, who is a lawyer, a mediator, an arbitrator, and a very eminent author on variety of issues. In fact, the things that I have read on Article 370 written by him, I remember several write-ups that I have come across, and his very celebrated work, Unraveling the Kashmir Knot. I mean, some of the celebrated works on Kashmir, which has been one of our festering wounds for over 7 or 8 decades of our existence as a republican system. So this is, I mean, the thank word will not be enough to really explain the kind of sentiments that we have for your spending time with us, sparing time for our students. It is so nice of you, sir, that you have spared your time to be with us this evening. I believe that this 2 days workshop on mediation is going to be a very special academic occasion. By your mere presence, I believe, and the things that you are going to present, it will become a very special occasion for us. I take this opportunity to welcome you on behalf of University School of Law and Legal Studies and my university, and on behalf of my faculty colleagues. I extend a very warm welcome, sir. Thank you so much for being with us, sir. Over to you, Ishita.
Thank you so much, sir. Now, I would like to introduce Dr. Aman Hingorani, who is a practicing lawyer and a mediator at Honorable Supreme Court and High Court of Delhi. He has been appointed as an arbitrator by Delhi High Court and acts as an arbitrator with PhD Chambers of Commerce and Industry, and also an adjunct faculty to teach students and run training courses for judicial officers, lawyers, and law teachers at several institutions in India, including National Judicial Academy, Bhopal, Campus Law Center, University of Delhi, and Indian Law Institute, New Delhi, as well as abroad, including University of Oxford, Warwick University, and South Asian Institute of Advanced Legal and Human Rights Studies, Dhaka. Dr. Hingorani has previously addressed national and international audience on Kashmir issue and his celebrated book, Unraveling the Kashmir Knot, published by Sage Publications, which received rave reviews from former justices of Supreme Court, journalists, and diplomats for its unique perspective on Kashmir. He is also a frequent contributor to Live Law and has been writing constantly on Article 370 in the days following its abrogation. It's a pleasure to have you with us today, sir. It's a great opportunity for all of us to enhance our knowledge. Over to you, sir.
Professor Singh, Dr. Vanna, Dr. Zubair, faculty members, law students, friends. Thank you all for being here and giving me an opportunity to share my thoughts on mediation, which is a subject quite close to my heart. I have been teaching mediation since 1998 and practicing mediation since then. And it is indeed gratifying to see that mediation is now taking roots in this country. We have had more or less institutional mediation in this country, not private mediation. That is yet to become a lucrative practice, but next mediation, institutional mediation is here to stay. Now, mediation, in my view, is in line with the broader role of a lawyer. The law students who are going to be entering the bar would be well aware that they're not only required to act within the adversarial system as lawyers to represent a client, but they are expected to have the skills to be able to address the grievance of the clients by using different mechanisms outside the adversarial system. And these could be negotiation, it could be mediation, it could be different permutation combinations of other ADR mechanisms. And perhaps I'm sure you would have gone through these mechanisms during your law school. What I intend talking today about is, should you be a mediator? Should you become a mediator? How would you mediate? What are the skills you require to mediate? And tomorrow we'll be discussing online mediation, which has gained impetus with the COVID-19 pandemic. We have had no option but to move virtually. But that has opened also an entire new area of facilitating businesses and handling business disputes, because apart from the kind of skills we're talking about today, law students would also need to have technological skills to be able to do online mediation. They should be familiar with artificial intelligence, smart contracts, and so on and so forth, so that tomorrow, if they are asked to do a mediation, if they've been appointed as a mediator through a smart contract, and they do want to insert the mediation settlement agreement in the blockchain so as to trigger off the release of virtual currency from A to B in terms of the settlement, the mediator must know what this whole process is. What are these terms? What is smart contract? What is virtual currency? What is the kind of disputes that arise in mediation for businesses? Because now most of the contracts around the world are smart contracts, something which may not necessarily accord with Section 10 of the Contract Act. We still use signatures which are not recognized. The blockchain technology generates signatures which are not recognized by which are not under the Information Technology Act, as well our Information Technology Act. So this we'll discuss tomorrow. But today what I intend discussing is, how would you mediate? How would you be able to redress the grievance of your client, not necessarily by saying the other side was bad or trying to fix the blame on the other side? Can you reach your objective without doing that? Now, a textbook example of the distinction between the adversarial mode of litigation and arbitration on one side, and the non-adversarial way of handling disputes, that is through mediation, negotiation on the other, is that of an orange. I'm sure you would have read this in different books. And for those who haven't, I can quickly summarize what it is. Suppose there's a dispute between A and B over one orange. Within the adversarial system, you'll be trained as lawyers to say whether your client A has title to that orange or your client B has title to the orange. So if you're lawyers for A and B, each one of you will be saying, my client has the right title and interest in this orange, so I want it. Or rather, my client wants it. The court, the third neutral party, should pass an order handing over that orange to A or B, as the case may be. In mediation, the third neutral party tries to get into the underlying interest. Why does A want that orange? Or why does B want that orange? If A says, I want that orange, the peel of the orange to make, say, pickle, and B says, I want the inside of the orange to make juice, then the mediator will say, forget about the legal rights as to who has title to the orange. A can keep the peel, B will keep the inside of the fruit. So it's a win-win situation. Both sides get the underlying interest satisfied. That brings about a transformation of that conflict in a win-win situation. No one side is winning, no one side is losing. Both sides are winning. So this is a textbook example which is given by many authors as to distinguishing between litigation, where conflicts is decided, one side will win, one side will lose, with the non-adversarial way of resolving a dispute, where you transform the conflict, where both sides win. So far, so good. But if you think about it, this was possible only because there was a communication between A and B. If we look back, let us see what we do in litigation. Like I mentioned, A has a dispute, he'll go to his lawyer. B has a dispute, B will go to his lawyer. The lawyers will take the version given by the respective clients, abstract the socio-economic context, see what are the rights and liabilities, and prepare a case to be decided by the judge or the arbitrator. So the person who decides the case is not the one who A or B know. That is, a third neutral party who's unknown to A and B is deciding the dispute of A and B. In the process, the communication between A and B has dried up. There is no communication. There's still prejudice between A and B. In mediation, we try to do the reverse. We try to empower A and B. We bring in the socio-economic context. So long we're acting within the parameters of the law, we keep aside the legal rights and duties. And we say, how would A and B, how would you like to have your dispute resolved? So it is empowering the parties by reopening communication cycle. So the parties themselves decide as to how to be able to resolve the dispute. And the role of a mediator is basically to facilitate this communication, this negotiation between A and B. So if we keep aside textbooks, definitions, etc., basically what a mediator is doing is mediators hearing A, mediators hearing B. In a neutral, objective manner, the mediator is asking them to, is trying to facilitate a settlement between A and B themselves. And in the process, the mediation is trying to break the conflict cycle. I'm sure you would have studied what a conflict cycle is. Again, very simply, a conflict cycle is a cycle that starts by one person modifying their behavior towards another because of a wrong self-analysis. Let me put it more simply. Each one of us wants something in life. We have ambitions, we have our aims. If we get it, we're very happy. If we don't get it, then we sit down and think, why aren't we getting what we want? We do analysis, a self-analysis. If I modify my behavior, if I behave in a particular way, I'll get what I want. Now, if that analysis is correct, then you'll get what you want. But if that analysis is wrong, then your modified behavior would have invited a reaction from the other side, would again act even more adversely to you, which will force you to further modify your behavior. And that starts a conflict cycle. The job of a mediator is to get into the mind of that party, to understand where the self-analysis went wrong, so that the mediator can then reason with that party or show a different perspective to that party, so that that party becomes more rational, steps back from the stand that party is taking to the reason why that person is taking that stand. You step back from the problem, and then that party pieces forward a rational way forward. So you'll see what a mediator has to work without compromising on neutrality, without getting attached to either A or B, without counseling A or B, without giving advice to A or B. The mediator has to make the party come back from the stand they've taken to the underlying interest. Now, if that is the job of a mediator, the mediator needs some skills. The mediator must have good communication skills. Communication, I'm sure you've studied, is not a unilateral process. One person says something, the other person, and the person says it through a medium, the other person downloads it from that medium, and then gives a feedback. And A will say something from his conditioning, his prejudices, his thought process. It may or may not be downloaded necessarily in the way A meant it by the other side. So communication itself is a multifaceted process where there can be an inhibitor at any level. The manner A speaks, or the B understands it, or in the medium itself. There could be communication inhibitors. So it's the job of a mediator to effectively communicate, to identify communication inhibitors, to overcome those communication inhibitors, to get a full flow of information. I'm sure you have studied communication skills, different kind of skills that are there, listening skills, where a person is, where the mediator is simply listening to the person to gather information. They're active listening, passive listening. People can listen to almost 4 times the number of words they speak. So listening is a very effective technique. Then questioning skills, and so on and so forth. I'm sure you have studied all these. If you haven't, we can have a discussion on this later on. Then there are non-verbal communication skills, the body language, the eye contact, the way a person stands, the posture, the hands, the way a person dresses. All these are communication skills which a mediator must have. Then the mediator must have negotiation skills, facilitative skills, which we'll discuss, social skills, and then technological skills. So in this background, if you see what is the definition of a mediation is a voluntary process. Obviously, if you want A and B to confide in the mediator, they have to do it with a choice. Mediation is a party-centered process. You're empowering the parties. Mediation is a non-binding process. Nobody's going to start lowering down the defenses and share their intimate thoughts if they are afraid that they're going to be held to it. So it's without prejudice talks. So it's a non-binding process. It must necessarily be a confidential process. No, A will not confide in B, or B will not confide in, A will not confide with the mediator, or B will not confide with the mediator, unless they are assured that whatever they're saying will remain confidential. Then mediation is a structured process, and we'll discuss the structure. There's nothing called a random, spontaneous mediation. It's a scientific way of handling a conflict, which we'll discuss. So you'll see mediation as a process of voluntary, party-centered, non-binding, confidential, and structured process. And this process is controlled by the third party who has to be neutral and credible. Then only the person will confide in that mediator. And that neutral and credible third party must have special communication, negotiation, facilitative, and social skills. And the role of the mediator is to assist in a binding negotiated settlement by the parties themselves. So the process is non-binding, but the settlement, which is the result of the process, should there be a settlement, that's a binding negotiated settlement. So this is a textbook definition of what is a mediation. And you'll perhaps be able to appreciate it better in context of the purpose of mediation being to empower parties to themselves take ownership of their own settlement. It is their settlement. And hence, a guiding rule in mediation, which unfortunately is not followed in this country, at least from my experience. I might be wrong, but to the best of my knowledge, in this country, mediators take over the process. They run the process, whereas the way a mediation should be run is that everything should come from the mouth of the parties, not the mediator. It's the parties who have to tell the mediator their priorities, their underlying interest, why they're taking a stand, how they want those priorities, how do they want those interests satisfied, what are the different options, evaluation of each options. Each stage of mediation has to be done through the mouth of the parties, not the mediator. And this is very important for the simple reason that the parties must be made to feel it is their settlement agreement. Only then they won't find ways of getting out of it. Rather, they'll adhere to it. It will be durable. They won't challenge it. And so, all this, the essence of mediation is to get the parties to give a free flow of information. Now, what are the mediation skills? The first skill obviously has to be able to reassure the parties that the mediator is neutral, credible, and the process is confidential. Now, how would you do that if you were a mediator? You can't tell the party I'm neutral. That's not going to be very persuasive. A mediator, by the conduct, the way he or she runs the mediation, will show neutrality. A mediator must have equal eye contact with both parties, must show equal deference to both parties, must allocate time equally between both parties, must use words of mutual application. Either of you can ask for a private session. Either one of you can bring, if you want to have a private session with A will be followed with private session with B, so that there's even-handedness between the two. The mediator has to be a neutral party having no interest either in the dispute or in the party. So it's the way a person conducts himself, they establish neutrality, they establish their credibility. Again, the mediator, as I pointed out, must be able to assure the parties that the mediation will remain confidential, and confidentiality is at several levels. Whatever said in the mediation room will remain confidential. As far as in mediation, as I'm sure you're aware of, you can have a private session. The mediator can have a private session with party A mediator can have a private session with party B. Around the world, the rule is that whatever said in a private session will remain confidential unless a party authorizes a mediator to tell the other side. In India, the rule is somewhat different. Whatever's told to a mediator in a private session can be disclosed to the other side unless a party says, don't disclose it. And so, as far as the mediator is concerned, he has to inform the parties that whatever you're going to be saying in the room, in a joint session will remain confidential, it can't go outside the room. Should you ask me not to disclose something in a private session, that also will not go outside the room or will not be disclosed to the other side. I think is there an issue with
So,
there's an issue with yes, am I audible?
yes,
Yeah,
yes,
you are audible,
Yes, sir.
sir. It's perfectly fine, sir.
Yeah, so in between, I think there was absolutely muted. But we'll continue. So I was talking about confidentiality, that whatever has been said in the mediation room would remain confidential. Should a party ask for a private session and say, in a private session, I'm giving you this information, but please don't disclose it to the other side, that will have to be confidential. Should the party, unless the parties otherwise agree, it's not permissible for a mediator to be a witness or an arbitrator or a counsel for either of the parties. And then confidentiality also extends to communication with the court in a court and ex mediation. A mediator cannot be asked to tell the court what transpired in mediation. Either there was a settlement or parties could not arrive at a settlement. So confidentiality is at several levels, and this again is something the party has to be assured of. Another facilitative skill of the mediator is to be able to control the process. As I pointed out, mediation is based on the principle of party self-determination. Parties have to decide, not the mediator. Mediator is only controlling the process. Parties have to make the free and informed choices. Mediator cannot impose a settlement on the parties. Having said that, that process which the mediator is controlling has to be a fair one, guided by principles of objectivity, fairness, justice, principles of natural justice. You have to keep in mind the rights and obligations of the parties, the usages of the trade concerned, wherever applicable. And to ensure it's a fair process, you must ensure, as a mediator, that the parties are showing respect for each other. They're not being abusive, they're not shouting at each other. And in many times, as mediators, what we see that we start aligning ourselves with one party. A mediator cannot do that. A mediator cannot be aggressive. It's a problem which has to be addressed, not the person. So the mediator has to keep an objective eye on the problem and detach feelings for the person presenting it. So these are some of the mediator can't afford to blame anybody. Mediator cannot say it's your fault. That will polarize people. So when we're talking about the mediator controlling a process, it has many assets, many layers to it. It's not simply as though a person being in charge of saying who will speak first or speak second. Then the mediator should be able to recognize communication inhibitors and combat them. The mediator must have the facilitative skill to take the sting out of the hostile or volatile comments made by a party, present the negativity of one party as a positive need to the other party. And many times we use techniques like neutral reframing to do this. So suppose a wife is telling in the presence of the husband to the mediator, he is selfish, he is self-obsessed, he's so full of himself, he never listens to anybody. I keep talking to him, he ignores me completely. Now the mediator should step in, otherwise because these hostile comments will vitiate the environment. But the mediator would step in to say, I understand that you feel the need to be heard. The underlying interest of the wife is she's not being heard. So you can't change what the wife is saying, but you can summarize that in a neutral manner, reframe it neutrally, reflect it back to the wife to say that you're understanding, you're acknowledging her concern of her underlying interest to be heard, so that the husband, who you've restrained from interrupting, would focus on the positive need of the wife to be heard, as opposed to the hostile words like selfish, self-obsessed, and so on and so forth. So the mediator has to be able to ensure that the environment does not get vitiated. because people are hostile to each other. Then the mediator must be able to generate momentum towards agreement and establish a conducive environment. And the way of doing that is always start with the easier issue. If there are 10 issues, start with the easiest one, then the second easiest one, third easiest one, go on the common areas of interest. So that you would keep saying, this has been resolved, this has been resolved, now only this teeny weeny bit is left. You're building a momentum that there's movement in resolving the conflict. Then the mediator must have the facilitative skills to recognize that the parties are arriving at a deadlock, preempt a deadlock should you be unable to do it. There are different strategies how to break a deadlock, and we will discuss this more in detail later on. Then the mediator should be able to draft an appropriate settlement. In this country, there's a big confusion about mediation and conciliation. In Salem Bar's case, Supreme Court said conciliation is a more proactive form of mediation. In the Afghan judgment, I'm sure you know about these judgments, the Supreme Court said they're interchangeable. But there's a difference in the legal status of a settlement agreement if arrived in mediation or conciliation. A settlement under the Arbitration and Conciliation Act of 1996, a conciliation settlement agreement has the same status as an arbitral award. It is like a decree of a court, it can be executed. A private mediation settlement agreement is like a contract. It can be specifically enforced in court, but it's not a decree of court. A mediation settlement agreement in a court-annexed mediation is like a compromise application under Order 23. It will be referred back to, the settlement agreement goes back to the court. Court disposes of the case in terms of the settlement agreement and passes a decree. So the legal status is different. But in the end of the day, it is a binding agreement. It can be executed or enforced. So as to be specific, and again we'll talk about the skills that are required to draft a settlement agreement. So these are the skills, broadly speaking. This is not being exhaustive, there are plenty more skills, but if these are broadly the skills, then how do you mediate? Now, from my experience of being a mediator for almost 25 years, I find it very effective to do a pre-mediation preparation, something which is not again being practiced in our courts, in the next mediation centers, or in the different institutions. When I'm a mediator in the Supreme Court or the High Court, all I get is an order of reference from the court saying this matter has been marked to the mediation center. Mediation center appoints the mediator, and the mediator meets the parties on the date fixed. So the mediator has no clue of what that case is. I might never have done intellectual property rights. That case may be on IPR, could be on trademark violation, could be on passing off, infringement. I won't have a clue. Even though I'm controlling the process, I'll be better suited to do that mediation if I have some knowledge about that law. But I would not have any knowledge about what the case is all about. In most jurisdictions around the world, mediators are not put in that situation. Mediators get pre-mediation briefing or summary so that they can analyze the dispute even before getting into mediation, before talking to the parties. And there are many models of analyzing the mediation dispute. One of the models which I've used in my own practice is what in many jurisdictions is called the listing model or the ranking model actually. Now, let me explain how I do it, how I get it done, so that, of course, it needs to be adapted whether you want to do it before starting mediation. You can even do it during the mediation process. Suppose there are parties A and B, and I'm appointed as a mediator. Before coming for mediation, A will be asked to fill up a particular form. A will be told that you know your dispute, you know your case. What, according to you, are your underlying interests? Rank your underlying interest in accordance with how important they are to you. Prioritize your interests. These interests could be, again, without being exhaustive, salvaging a working relationship, the best deal possible in the circumstances, the need to get an apology, the need to be vindicated, the need for a closure, the urgency in getting rid of this particular conflict. If you go in litigation, what will be the likely outcome? What are the costs involved, and so on and so forth. We are not on merits of the case, but what are the underlying interests according to A, which are most important to him. A will make a list of those underlying interests. A will then do a role reversal. A will think or guess these interests from the standpoint of B and will make those lists again as though he was B. What are the interests which would be most important to B according to A? And again, prioritize those interests. A would then put those two sheets in a sealed envelope and leave it for me to see before I get into the mediation center. This will be confidential information given to me. From A would be giving confidential information as to the A's interests and what he thinks are B's interests. Similarly, B would be giving two lists in a sealed envelope to me. What are the interests which are important to B, and what are the interests which B thinks are important to A? When I go to the mediation center, even before meeting the parties, I open the sealed envelopes. I have these four lists before me, two given by A, two given by B. I'll just compare and contrast. If I see some common underlying interest, I would know where to start from. I would know how to maneuver the conversation. I would get a framework to assist in negotiation. I would know what is the dispute all about. I would know who are the parties which should be present for mediation. Unlike litigation, unlike arbitration, where only the aggrieved or affected parties have to be there, in mediation, any person who can facilitate a settlement, any person who can block a settlement should be there. And that I would get to know by simply seeing the lists. So when I make my opening statement in mediation, I know all the people who are there are there. So this is one of the models of doing a dispute analysis. Another model could be walking the parties through Vartna. Vartna, I'm sure you're familiar with those concepts, doing a reality check. Many times parties have unrealistic expectations and you want to temper them down. So I could, even before getting to mediation, tell a party A to make a list of the strongest points of his case, the weakest points of his case, the evidence he has to substantiate each point, the points in respect to which he has no evidence. I would ask him to do the exercise from the side of B. Give me those two lists in an envelope. B would do the same exercise. I've seen it from my actual experience that once parties are made to write down the actual evidence they have to substantiate a point, their expectations get tempered. They become more realistic. They know that if they have to go to court, they may not have the evidence to prove what they're saying. And that makes my life easier as a mediator. The wife will not turn up and say, well, he earns 10 lakh rupees a month, I'll prove it in court, when his ITR return shows he earns 20,000 rupees a month. So it just tempers down, it makes life easier for everybody. If we do this pre-mediation dispute analysis, which is contemplated in pre-mediation summary, is contemplated in the Arbitration Conciliation Act. It is contemplated in the model rules framed by the Supreme Court. in Salem Bar Association's case. However, the practice of the mediation centers across the country is no pre-mediation briefing. And that is something which, again, I think requires to be reconsidered as to how to go about it. Now, once I've got my pre-mediation briefing, I'll go for the mediation. The mediation room should be ventilated, airy, seats have to be comfortable. The seating is important. It has to be a round table. All the parties have to be seated on chairs at the same level. Even the mediator has to have, there should be no distinction between the chair of a mediator and that of the parties. They all have to be at the same level. Since it's a party-centered process, the parties should be asked to sit closer to the mediator. So the mediator if the mediator is in the center, party A on his left, party B on the right. Lawyer of party A then next to party A, lawyers of party B next to party B. Lawyers should not be sitting next to the mediator. Parties have to be sitting next to the mediator to ensure that it's the parties who have to take a decision in the matter, not the lawyers or the mediator. It has to be a pleasant, informal, yet, of course, it is still a part, in a court and expedition, still part of the court process. So you can't be casual out there. But at the same time, it's not a court environment. It's a relaxed environment. You can meet parties as a mediator with a smiling face, shake hands, do namaste, depending on the party, whether rural, urban, senior citizens, women, so on and so forth. The demeanor of the mediator has to be neutral. Words have to be used very simple, plain language. Words of mutual application. I welcome both of you to the mediation center. Appropriate eye contact with both sides. A calm, moderate, business-like, deliberative tone. This is a process. You can't rush through it. The mediator has to be attentive. A mediator can't be sitting back on the seat in a lazy posture. The mediator has to show interest in the mediation process. Now, this mediation process starts with the opening statement, which sets the tone. So you have to keep it very simple. Every mediator can adapt it according to the style. So you can vary the language or whatever you want to say, but there are certain basic elements you must mention in opening statement. Your mediation will succeed or may not come to, or you may not come to settlement. All depends on your opening statement. It's crucial because here it is at this stage that the mediator builds the neutrality and the credibility and assumes control over the process. So the mediator must introduce himself or herself, standing, experience as a mediator, be optimistic, express hope there will be a settlement, ask the parties to introduce themselves so that you know all the necessary parties are before you. Ask the parties in which language you prefer to be addressed, how would you like to be addressed. Try asking a person from the army, try addressing a person from the army as Mr., they won't like it. Try addressing a doctor as Mr., again, they won't like it. So how would the parties like to be addressed? Welcome the lawyers. A very common mistake is that mediator tells the lawyers, thank you for coming. We don't require your services. Let me talk to the parties. I'll let you know when to come in. If you run down the lawyers, you exclude the lawyers from the process, no matter how hard you work with the parties, the lawyers are not part of the process. They can block the settlement. The lawyer must be made part of the process, but to welcome them, take their assistance, so that they themselves would then work on the clients to make them more realistic. Ask the parties about a previous experience in mediation. If they have had experience, they know the mission process, the opening statement can be a short one. If they have not, then you don't have a choice. You have to give a detailed opening statement. describing the role of a mediator, emphasizing the non-adversarial nature of the process, no recording of evidence, there's no judgment or reward or an order being passed. There's nothing being recorded there by the mediator in form of notes. And if the mediator wants to take notes, take the permission of the parties. Emphasize the voluntary nature, the confidential nature of the process. Address neutrality by using adequate eye contact, words, body language. Tell the parties in a court annex mediation that court fee will be refunded should there be a settlement. That itself is an incentive for many parties. Tell the parties that you as a mediator can go beyond the pleadings, can even bring other disputes for settlement in this mediation. State the ground rules. You can listen to mediation. Explain the mediation process, that there can be a private session with either party so that it does not come as a surprise to the parties. Address the whole issue of confidentiality. Talk about decorum being maintained. When one party is speaking, the other one should not interrupt. Each party will have equal opportunity. Talk about no party contacting the mediator outside the mediation center. Talk about the procedure, should there be a settlement, when there's no settlement, and so on and so forth. So there's an entire list of things that you need to do in opening statement while managing any kind of outburst, handling administrative matters like breaks or order representation. Ensure parties want mediation. Many times, from experience I can share with you, parties come to meet for mediation.
I'm sorry. I think someone has unmuted.
Okay.
I'm sorry.
Yeah. So from experience I can share from you in many court annex mediations, parties come and then say, well, we didn't really want mediation, the court sent us. So it's better to get a confirmation that the parties do want mediation. It hardly makes a difference who's the plaintiff, who's the defendant, or who's asked for mediation, who's not asked for mediation. Because in mediation, all parties are on the same footing. So you can invite either party to share the perspective, either party can speak first, or show the other party that they'll get full opportunity. After the opening statement, the parties are taken through different stages of mediation, whether in a joint session or a private session, to understand the problem, to understand the needs and interests, to define the problem, to redefine the issues, to identify the options, to evaluate the options, and so on and so forth. But all this has to be done from the mouth of the parties. Parties have to share the perspectives. Parties have to identify the problems. Parties have to identify the needs and the interests. Parties have to identify the options. Parties have to evaluate the options, not the mediator. So after the opening statement, we normally continue with the parties sharing the perspectives in the joint session, unless the parties say, we can't stand each other, we want a private session upfront. Then you get into a private session. So in a joint session, you will ensure that one party speaks without any interruption. Let the party speak. The mediator should not try to guess what the party is going to say, should not try to finish up what the party is trying to say. Party speaks first, then the lawyer or the party can supplement. Should anybody else want to speak, then the mediator should allow that person to speak. After both sides have spoken, start with the common ground, the easier issue. Keep summarizing what has transpired. Keep summarizing the progress made to build that momentum. Keep a ear open for any kind of a concession. Keep keep a lookout for the body language, the clues, the non-verbal clues that a party may be giving the mediator. So the mediator should gather information from the parties to uncover the long-term interests so that you can discover the common interest between them. And then get the parties, once you've taken each issue at a time, each interest at a time, how would they want to resolve it? What are the different options? Put each option on the table and get them to evaluate it and see whether it's acceptable to it or not. Should either party want to get into a private session or the mediator says you want a private session, then the mediator should conclude the joint session before meeting in private. When I say conclude, summarize this point where you're breaking off so that when you rejoin for a joint session after the private session, you know where to start. Private session with one party should be followed with a private session with the other party. Give equal time in private sessions to both parties. It establishes neutrality. Should one session take more, explain to the other side why it took more. This person was traumatized, this person had a lot of emotional venting, whatever it may be. Use private sessions to address concerns of parties, or if you want to communicate offers and counter offers, you want to allow parties to vent their emotions in a productive manner, you want to deal with unrealistic expectations, you want to handle a potential deadlock, you want to elicit various options, you want those options to be evaluated at times in the absence of the other side. You can use private sessions for all these kind of purposes. Avoid a private session where a party can be persuaded directly or where a party can communicate a compelling position. Yes, I owe this person 10 lakh rupees, but I just don't have the money. So I'm not denying my liability, but I don't have it. I can pay installments. Then don't go in a private session. Let that party explain the compelling circumstances to the other side. The entire approach of the mediator is to shift the parties from the stance they've taken to the underlying interest. And then there are many techniques which you would probably have studied while doing mediation, like neutral reframing is one of them I mentioned, summarizing, deferring, acknowledging, handling reactive de-evaluation. That basically means that many times proposals get devalued because the one party is making it. If A and B don't like each other, and A is making a proposal which is otherwise reasonable, but B is objecting to it because it's A who's making the proposal. So what happens is we get into a private session. A will tell the proposal to the mediator. Mediator will take ownership of the proposal and go back to the joint session and present it to B as though it is coming from the mediator. So though you have tried to neutralize or handle the devaluation of the proposal as a reaction to A. And that is what we call handling reactive devaluation, where the mediator takes ownership of an information or a proposal of a party in order to preempt the other party from reacting negatively to the proposal, solely based on the fact as to who is making the particular proposal. So there are several techniques which a mediator can use to get the parties to shift to the underlying interests and to create a congenial environment for negotiations. Then there are strategies to handle emotions. Emotions is a very strong tool in mediation. You can invite party A to disclose the emotional impact of the situation on the other side. Many times we say or do things we don't understand or appreciate is caused immense trauma to the other side. So if a party said something without intending to be hurtful, let the other side show the impact that side had because of this hurtful comment. Other ways of handling emotions is getting into a private session or moving on to an easier issue, or actually verifying the sincerity of that emotion. Many times a lawyer tells a party, just go start crying before the mediator. You'll get the sympathy. So that emotion may not actually be sincere. So it's the job of a mediator to see whether the emotion is sincere, identify the source or reason behind the emotion, and address the cause. as opposed to simply getting bogged down with the behavior of that person who's emoting. Yet another area of emotions is restorative justice, something which we in this country again don't do in mediation. Restorative justice basically is to convert negative emotions into positive emotions, to bring about a closure to a trauma. Take example, let us assume there's a divorce, a mediation relating to a divorce between A and B, and the parties are coming to a settlement. They're going ahead with divorce by mutual consent. But even if there's a settlement, it does not necessarily mean that the parties have overcome the trauma associated with that bad marriage. Whether it's a husband or whether it's a wife, they may simply be saying, why has this happened to me? Am I a bad person? That trauma is still there, even though there is a settlement. So when we do restorative justice, we use certain joint sessions where we work with the parties to bring a closure to the unanswered questions, so that along with the settlement agreement, there's also closure to the trauma. So they're able to move on in life. These practices, for this, you need a separate kind of skill sets, because here the focus is not as to, the focus basically is in acknowledging that harm has been caused, hurt has been caused. What will it take to undo that harm or hurt? We can't wish away that harm or hurt, but at least we can notice it. We can do something to address it. We can bring about answers to the questions being asked by a particular party so that they get it out of the system. So that's a different kind of skill sets. For the shortage of time, I won't get into that. But these are again strands of restorative justice which are used in other countries in mediation. We in India simply don't do it in a structured manner, at least. Nor is it there in many of the mediation handbooks or rule or the practices of different mediation centers. Then it's also important to use apology as a tool in mediation, that is to acknowledge and express regret. Nobody is going to say sorry, but both sides may simply agree to regret the happening of the events in the manner they happened. So the phrasing of the words are important. It's important to give a face-saving exit to a person, because nobody wants to lose face. So if you can come up with a kind of a settlement option that gives an honorable exit to a party, they may just exit that conflict rather than continue with litigation. Similarly, silence is a very important tool. Suppose a person, I had mentioned about the mediator getting into the mind of parties and trying to decondition them. Deconditioning is a process. It takes time. A party may want time to think before speaking, to choose whether to go on or not to go on, to let go of something that was very important to that party. The mediator must give the space to a party by keeping quiet. It will demonstrate interest, respect, patience. The mediator can actually use this time to observe the party, pick up non-verbal clues. So should there be silence in the room, or should there be, even in a private session, should one party just be silent? Let the party remain silent till that party chooses to speak. Give the party space. Silence itself, as I pointed out, can go a long way in bringing a kind of a rationality in the way a person thinks. Then handling impasse, as I mentioned, should parties be deadlocked despite everything, there are many techniques. Shift gears between joint session, private session, do role reversals. If A is sitting on one side and B on the other, ask A to get up and sit on B's seat, let B sit on A's seat, and ask him to think how would they react if they were the other side. take a break, defer mediation, bring humor, proceed on an easier issue, ask parties how they would want to break the deadlock, threaten to end mediation, bring third party or expert intervention, allow emotions to emerge, take a break. There's so many different ways you can simply handle an impasse. Finally, should there be a settlement, how to draft a settlement agreement. A mediator must always summarize the terms. First of all, it is open to the parties to draft a settlement agreement, but my strong advice is they should not. They'll probably use terms which are in their favor, which once they're put in black and white, is very difficult to get rid of them. So, for instance, if A has agreed to pay B 1 lakh rupees, A says A will pay B 1 lakh rupees by check. B turns around and says, what if the check gets dishonored? I don't trust you. You pay me by cash. A says, well, if you can't trust me, I don't want to settle with you. And so the settlement breaks. Now, if a mediator was going to draft that settlement agreement, mediator would simply say, A will give B 1 lakh rupees by demand draft and will tell the parties that is standard practice. So a mediator can preempt many issues by doing the drafting of the settlement agreement. But for a mediator to do that, the mediator should first orally recite, clarify, and confirm the terms of settlement before putting them down. As I pointed out, a settlement agreement can be executed or enforced. So the terms have to be clear, concise, complete, concrete, realistic.
I'm sorry, sir.
All
I
clauses.
guess someone unmuted. Sorry.
I'm sorry.
You can continue, sir.
Dr. Raman, you are muted. Vaibhav?
Yes, ma'am.
See, sir, mic is mute.
Yes, ma'am. I'm checking. This mic is mute actually. I have asked him to unmute actually from here. I guess there must be some connection problem. So
I've
you have
seen.
left the session as well. Yes, ma'am. Okay, so sir have rejoined the session.
Just a second. Dr. Raman, your mic is, you are muted.
Am I audible right now?
It's, connection is not proper, I guess.
Okay, so there must be some connectivity issues, ma'am, I believe.
You can stop recording for a while. Vaibhav?
Yeah, yeah, sure, ma'am. I'm doing it.